You open the chart. The template loads. Physical exam, neurological section, already reads intact. Full neuro exam, all domains normal, documented in seconds. You sign the note and move on. 3 floors down, a physical therapist documents that the patient cannot bear weight on the left side. A nurse notes new left-sided drift during a bedside assessment. A consultant's note describes subtle speech changes. Your note says neurological exam intact. Their notes say otherwise. Now imagine this. 18 months later, a plaintiff's attorney has all 4 notes side by side. Yours, the therapist's, the nurse's, and the consultant's. They have the audit trail showing your total time in the chart was unrealistically low for the documented work. And they want to know how you performed a multi-domain neurological examination that contradicts what 3 other providers observed. This is the charted defense. I'm Bryan, alongside Sarah and Michael. Today we're looking at what happens when pre-populated EHR templates document a neurological exam that does not match reality, and how audit trails become most damaging when the total time a physician spent reviewing and documenting is inconsistent with what the note claims was done.
I want to start with something practical. I'm not here to tell anyone they're documenting wrong. Every hospitalist I know is fighting the same battle. Too many patients, not enough time, and an EHR that sometimes feels designed to slow you down. Templates exist because the volume demands them, and used well, they're a legitimate tool. You can template in your labs, your imaging results, your vitals, your active diagnoses. That is objective data, and it is what it is, but your physical exam findings and your clinical reasoning should be in your own words, reflecting what you actually assessed and decided that day. When the exam section of your note reads like a template, when it looks identical to yesterday's note or to every other patient on your list, a plaintiff's attorney will argue you never saw the patient, and the jury will have to decide who to believe, your testimony or the record you signed.
Sarah. When a chart reads, neurological exam intact, what does that phrase actually communicate, clinically and legally?
Clinically, a neurological examination spans multiple domains. Standard references describe it as including mental status, cranial nerves, motor function, sensory function, reflexes, coordination, gait, and balance. That is a multi-system assessment. But the phrase neurological exam intact collapses all of those distinct findings into a single conclusory statement. It doesn't specify the scope of the exam, the individual findings, or which components were actually assessed. Some clinicians may use that vagueness intentionally, believing it suggests a thorough exam while preserving flexibility. But in litigation, that ambiguity more often works against the clinician than for them. In litigation, the ambiguity cuts two directions. If the patient later deteriorated neurologically, a plaintiff may argue the documentation falsely suggests a thorough examination that would likely have detected early deficits. If the clinician intended a limited screening, the defense may argue the phrase meant exactly that, but the lack of specificity makes that explanation harder to support. And the problem compounds when other providers, nursing, physical therapy, consultants, documented contradictory neurological findings during the same time frame.
This is the part that catches physicians off guard. You know what you did at the bedside. You walked in, talked to the patient, watched them move, assessed their speech. But if the note just says neuro exam intact, the audit trail shows you were in the chart for a very short time. The record doesn't reflect what actually happened. The record reflects what the template generated. And here's the clinical reality that matters. Even educational materials that describe a 5-minute neurological examination outline a structured assessment covering mental status, cranial nerves, motor, sensory coordination, and gait. Studies on the NIH stroke scale, a focused neurologic deficit scale, report mean administration times in the range of 6 to 8 minutes, with individual assessments ranging from 4 to 12 minutes, depending on the setting. A multi-domain, fully normal neurologic exam documented via a single click in seconds looks like a documentation artifact unless the note clearly indicates what was actually done and when.
This brings us to the audit trail. The metadata the EHR generates behind the scenes. Sarah, what does an audit trail actually capture?
EHR audit trails record who accessed a chart, when and where it was accessed, what was done, whether the record was viewed or edited, and sometimes how long it was open. This is system-generated metadata. The clinician doesn't create it, can't alter it, and in most systems can't delete it. And courts are increasingly treating this metadata as discoverable evidence.
Walk us through how courts have handled audit trail discovery requests.
Several cases illustrate the trajectory. In Gilbert v. Highland Hospital, a 2016 New York case, the plaintiff sought the audit trail of a decedent's medical records. The court rejected the hospital's fishing expedition argument and compelled production, holding the request was material and necessary, where the allegations concerned whether an ED attending actually evaluated the patient. The court emphasized that audit trails can show access, edits, and how long records were opened. In Vargas v. Lee, a 2019 New York appellate case, the court reversed a lower court's denial of audit trail discovery. It held that the plaintiffs met the threshold, showing that the audit trail was reasonably likely to yield relevant evidence regarding timing, substance of postoperative care, and record completeness. The appellate court cited broad disclosure policy and treated the audit trail as showing access times, locations, and changes. And in Hall v. Flannery, a 2015 federal case out of Illinois, the hospital argued portions of its EPIC audit trail were protected under peer review and work product privilege. The court disagreed. The audit trail was automatically created as part of the record and simply reflected who, when, and what was done. In the EHR, privilege arguments did not bar disclosure.
What physicians need to understand is that the audit trail is not some theoretical risk. These are real discovery motions that courts are granting. The metadata exists whether you think about it or not. And when a note says neuro exam intact, but the audit trail shows the chart was open for a very brief period, a plaintiff's attorney has the foundation for a credibility argument, not necessarily about the care itself, but about whether the documentation accurately reflects what happened.
Sarah, the legal risk here extends beyond malpractice, correct?
It does. Template-driven normal findings can also create exposure in payer enforcement contexts. The U.S. Department of Justice has publicly described EHR copy/paste and template functionality as being used to create what it called the illusion of work. Documentation that makes it appear extensive services occurred when they did not, in support of billing. In a 2016 False Claims Act resolution involving a home-based care provider, the DOJ described EMR copy/paste as enabling the migration of old notes to create the appearance of work not performed in support of billing. And in U.S. v. Mittal, a 2023 federal complaint filed in the Southern District of New York, the government alleged that EHR templates were designed to populate symptoms with checklists that auto-generated lengthy symptom narratives, that the notes were inconsistent with patients' brief interactions, and that staff were told to vary the template entries to avoid suspicion.
I want to be careful here. The Mittal case involves allegations of deliberate fraud, which is a very different situation from a hospitalist clicking through a template under time pressure, but the underlying principle is the same. When documentation doesn't match reality, it creates risk. In the malpractice context, it's a credibility problem. In the billing context, it can become a compliance problem. The template doesn't care about intent. It documents what it's configured to document.
Michael, how prevalent is this issue in practice? Is the templated normal exam an outlier, or is it the norm?
The data suggests it's very much the norm, or at least the mechanism behind it is. A widely cited analysis of more than 23,000 inpatient progress notes found that a typical note contained only about 18% manually entered text. Roughly 46% was copied, and about 36% was imported. The vast majority of what appears in a progress note was not freshly written for that encounter, and ICU-focused research has documented substantial copying behavior in physician notes, reinforcing that normal exam text can persist day to day, even when clinical changes actually occur. A systematic review on copy/paste practices reported that routine use was common among large majorities of clinicians. Some studies put it in the range of 2/3 to 9/10, and identified consistent risk themes. Note bloat, outdated information propagation, and patient safety hazards.
From a regulatory perspective, this is where the legal and clinical risks converge. The Federation of State Medical Boards EHR professionalism framework is specific. Copy/paste is inappropriate for documenting entries not derived from the patient encounter unless clearly noted as copied, and content that is copied must be verified. The FSMB explicitly warns against documenting work not performed.
And it's worth noting, this isn't a new behavior. Before the EMR, physicians physically copied information from the previous handwritten note into the current one. We've always carried forward data. But the manual labor of transcription forced a degree of re-engagement with the content. You had to read it as you wrote it. A single click doesn't require that same re-engagement, and that's where the risk concentrates. The mechanism, pulling forward text, using a template, isn't inherently wrong. It's a practical tool. The question is whether the clinician verified that the pulled forward text remained true for this patient at this time. And the honest answer for most of us is that the verification step is inconsistent. When it's a stable patient on day 4 and the neuro exam truly hasn't changed, the risk is low. When it's a patient with an evolving complaint, new weakness, altered mental status, a fall, and the note still reads neuro exam intact from the template, that's where the exposure concentrates.
Sarah, beyond the case law and the FSMB, what regulatory frameworks bear on this issue?
Several layers. At the federal level, the HIPAA security rule requires audit controls, mechanisms to record and examine activity in systems that contain or use electronic protected health information. This is the baseline expectation that access and edit activity can be logged and reviewed. Medicare hospital conditions of participation require medical records to be accurately written, promptly completed, properly filed, and accessible. These are often used as background norms in litigation, and inaccuracies in exam documentation can be framed as noncompliance. Joint Commission materials addressing documentation hazards, notably copy/paste emphasize patient safety risk, and recommend controls to prevent propagation of inaccurate information. And a relevant detail: Joint Commission Stroke Measure Abstraction Guidance recognizes that note timestamps may not equal the time an assessment was performed. It instructs abstractors to record the performed time if documented, and to use the timestamp only if performed time is absent. That distinction directly reinforces documenting when the neuroexam was actually performed, rather than relying on auto-generated note timestamps.
And at the institutional level?
The HHHS Office of Inspector General reported, based on a survey of hospitals, that a substantial proportion indicated they could delete, disable, or edit audit logs, highlighting governance risk. And CMS has published EHR Compliance Program Guidance emphasizing standards of conduct, internal policies for EHR use, staff education, and compliance with federal and state statutes. For institutions, audit logs and note versioning should be treated as litigation-grade infrastructure.
Michael, this is where we bring it to the bedside. What can a physician do differently starting on their next shift?
5 things. First, document the exam you performed in your own words, not the template's words, not yesterday's words, yours. Instead of neurological exam intact, describe what you actually assessed and tie it to the clinical context. For example, neuroscreen, alert and oriented ×3, speech clear, face symmetric, moves all extremities against gravity, gait not assessed, patient on bed rest. That tells the next clinician, any future reviewer, exactly what you did and what you didn't do. Build smart phrases that force scope selections tied to the chief complaint, but make sure the output reads like a physician wrote it, not like a checkbox generated it. Second, time anchor when it matters clinically. If you're evaluating a patient with an acute neurological complaint, new weakness, speech change, altered mental status, document the time the assessment was performed, not just the time the note was signed. Joint Commission Abstraction Guidance distinguishes performed time from note timestamp. In a time-sensitive case, that distinction can be the difference between a defensible record and a credibility problem. Third, verify before you sign. If any part of your note was pre-populated, copied forward, or imported, read it before you sign it. The FSMB framework treats unverified copy/paste as inappropriate. Make this a final read-through habit. It takes 60 seconds and it forces you to catch the note that still says lungs clear on a patient you just started on supplemental oxygen. If it's in your note, you own it in a malpractice case. Fourth, don't copy your physical exam forward. I would take this further than most guidance does. Don't copy any exam forward, even if the findings are genuinely unchanged. Identical exam language appearing across multiple consecutive days creates an image for a jury that is difficult to overcome. It suggests you're not actually examining the patient, you're just carrying forward documentation. A fresh, brief note, even if it says the same thing in your own words, reads differently than a copied block. Write a new exam each day. It doesn't have to be long. It has to be yours. And fifth, understand that your documentation workflow is visible. The audit trail captures when you opened the chart, how long you were in each section, and when you signed. I'm not saying you need to spend more time in the chart for the sake of the audit trail. I'm saying your documentation should be consistent with a reasonable clinical workflow. If you examine a patient and then batch your documentation later, which is how many of us work, and there's nothing wrong with that, the chart open time may not reflect exam time. That's fine, as long as your note doesn't imply an exam that the metadata can't support.
To bring this together, the pre-populated EHR template is a tool. It's not inherently a problem, but when it generates documentation that doesn't reflect what actually happened at the bedside, and when other providers' notes and the EIHR's own audit trail record the discrepancy, the template becomes the evidence.
Courts across multiple jurisdictions have compelled production of audit trails. They've rejected privilege arguments. They've granted discovery specifically because discrepancies between narrative documentation and EHR metadata are considered material. And parallel enforcement theories from the DOJ and OIG treat templated documentation that misrepresents care as a compliance issue, not just a documentation preference.
Here's the bottom line. The template doesn't protect you. The template documents what it was configured to document. Your protection comes from a record that reflects what you actually did, when you did it, and why. That's what makes a chart defensible, not the word intact, but the specificity behind it.
That's going to do it for this episode. If this changed how you think about your documentation workflow, share it with a colleague. The risk is real, but so is the fix. And it starts on your next shift. For the Charted Defense, I'm Bryan. Thanks for listening. This episode is for educational purposes only. It does not constitute legal advice or medical advice. Laws, regulations, and standards of care vary by jurisdiction. Case details are drawn from publicly available court records and government sources. Consult qualified legal counsel for advice specific to your situation.